Hello attendees of the Business Student Research Forum 2018. My name is Daniel Keller. I'm an MBA student at Louisiana State University Shreveport. My research project is titled Employment Discrimination Cases, Examining the Facts, Comparing the Awards or Damages, and Reviewing the Outcomes. During this project, we will establish the guidelines and review the results of employment discrimination, mediation, and litigation to offer insight into what options may best suit a worker suffering employment discrimination. This research was assembled using the past 2 decades of Equal Employment Opportunity Commission statistics on charges filed in litigation. That data was then contrasted against existing case law, precedent, outcomes, and scholarly works on employment law. The information from the EEOC and the scholarly sources is both qualitative and quantitative. The primary result of this research will determine at a basic level if a party suffering discrimination would receive a larger award with EEOC litigators or with private counsel. As this research will show, the vast majority of discrimination cases do not conclude with a verdict in a court of law. Another question this project will seek to answer is the prevalence of larger damage awards by state and if there is a discernible variation. The number of individuals filing cases with the EEOC has remained fairly static over the past 2 decades. Variances in filings can be mostly attributed to economic factors, which will be discussed later in this presentation. There are 10 distinct charge categories the EEOC tracks in its statistics. They are race, sex, national origin, religion, color, retaliation, age, disability, Equal Pay Act, and GINA, the Genetic Information Non-Discrimination Act. GINA was passed in 2008, and therefore its data is only available from 2010 forward. Race and color charges can be done individually or paired depending on the type of discrimination suffered. Age, color, disability, and religion have all been trending higher over the 20-year tracked period. Most notable is the increase in retaliation charges, which have doubled over the last 20 years. Retaliation charges are commonly filed alongside another charge or multiple charges, and are often the trigger that leads an employee to file in the first place. This is unique, as often this charge stands where others are dismissed, due to falling outside the applicable window, 180 days in most cases, in which charges can be filed. These categories are usually mirrored by most states with more stringent discrimination laws, but may have different individual administrative deadlines, and these states may have additional protected categories. Once the EEOC has received the complaint, the employer is notified and the EEOC determines next steps: mediation, investigation, immediate dismissal, etc. If the investigation does not produce clear findings, the charges may be dropped for further pursuance, but the injured party may receive a right to sue notice. This notice is required to file suit in federal court for all employment discrimination cases, with exception to age discrimination and Equal Pay Act charges. Should the entire process be followed but the EEOC elect not to litigate, they will issue a right to sue notice. It should be noted that a right to sue notice is not required to file suit at the state level unless the state has a specific requirement for this. Settlements, successful conciliations, withdrawals with benefits, and unsuccessful conciliations are all considered merit resolutions. Merit resolutions either provide favorable outcomes to the charging party or they indicate that the charge has or the charges have merit. 98.2% of charges filed with the EEOC are resolved or closed without a notice of right to sue due to meritorious condition. Of those that are not closed due to a lack of reasonable cause or for administrative reasons, 87.4% are settled or mediated by the EEOC. Data on individual cases closed for lack of reasonable cause that attained a notice of right to sue and then went on to private litigation are not available for comparison to EEOC outcomes, nor would this be pertinent to the comparison in this research. The EEOC sets out to right the wrong committed by the employer but does not seek punitive damages in the majority of cases it resolves without litigation. According to the EEOC, remedies for employment discrimination, whenever discrimination is found, the goal of the law is to put the victim of discrimination in the same position, or nearly the same, that he or she would have been if the discrimination had never occurred. The types of relief will depend upon the discriminatory action and the effect it had on the victim. For example, if someone is not selected for a job or promotion because of discrimination, the remedy may include placement in the job or back pay and benefits the person would have received. As such, the vast majority of cases the EEOC finds meritorious are settled or mediated. Of those remaining cases that are found to have merit but not successfully conciliated or settled, 11.4% are litigated by the EEOC. The rest are provided a notice of right to sue. Both the monetary awards collected from litigation and the number of suits filed by the EEOC have declined over the past 20 years. The number of lawsuits has trended down by 65%, while monetary awards have trended down 51%. This decline may be offset by the increase of settlements and withdrawal with benefits over the same period. While the occurrence rates have increased, settlement amounts in these cases are frequently confidential, and those that are made public are often an aggregate of payments or inflated, rendering them improper for comparison against private counsel settlements. One important element to address in the data is the driving factor behind charge filing rates. Viewing the actual annual rates of charge filings, the numbers show significant variation. These variations can be generally attributed to economic and employment conditions. Periods of market contraction, substantial layoffs, and/or economic instability are often accompanied by or precursors to sharp increases in charges filed with the EEOC. Employees may be protecting their jobs against what they see as vulnerability due to discrimination or responding to what they consider to be an unjustifiable termination. While there is not perfect correlation, McLeod and other scholars have shown that the unemployment rate does indicate an impact on the number of charges filed. So what do these trends reflect? The number of successful conciliations over this period has remained nearly flat, showing only a marginal decline, and this can be attributed to spiking numbers in the early to middle part of the range. Overall, this number in 2017 is within 10% of the 1997 total successful conciliations. But the number of settlements and withdrawals with benefits have increased 28.5% and 87.1% in frequency, respectively. Over the same period, the distribution of unsuccessful conciliations clearly shows a right skew. It is reasonable to associate the significant increase in merit resolutions, such as settlements and withdrawals with benefits, with this decrease in unsuccessful conciliations. Or in other words, less cases are going to litigation via the EEOC. When viewed in a consolidated chart, these numbers visibly offset each other. The next question we must address: what damages can a filing party attain with the EEOC? All cases filed with the EEOC are constrained by caps. The size of the cap for each case is determined by the size of the employer with regard to the number of people it employs. This cap includes both compensatory and punitive damages. In other words, this represents the total the plaintiff can hope to collect. Private counsel damages are less constrained if filed in state courts. Certain states defer to the federal guidelines, but many others do not. Attorneys are not likely to accept a losing case, so a determination of the case strength and potential outcome will be weighed by the plaintiff's attorney. Most employment discrimination cases, especially those with large damage awards, are likely to be appealed. Therefore, most courts rely on the 3 Gore guideposts when considering damages. These guideposts originated from the substantial punitive damages awarded and later reduced in BMW of North America Incorporated v. Gore. A ratio of compensatory damages to punitive damages is generally applied as a maximum, and this is mostly attributed to the first guidepost, reprehensibility. Considered the most important guidepost, the boundary that is used to rein in large punitive damages is the Due Process Clause of the 14th Amendment. Punishments that are considered grossly excessive in light of the evidence may be reduced on appeal. This is given the most latitude where a company is found to have engaged in reprehensible behavior, where the behavior establishes a pattern of disregard for established law, and where the punishment is intended to discourage other parties from similar behavior in the future. From an employer and insurance provider standpoint, certain states pose a higher risk of employment discrimination lawsuits being filed. This can be due to many factors, including expanded tort protections for employees, workforce makeup, presence of expanded impacted populations, vulnerability to adverse economic conditions, and others. Many states have more stringent employment discrimination protections, and in addition to federal categories, some states specifically provide protections for sexual orientation and gender identity. Some states, such as Alabama, have no general anti-discrimination statute, while other states, such as Wisconsin, Oregon, and Vermont, have strong anti-discrimination statutes and provide relief for compensatory damages, punitive damages, as well as attorney fees. While Campbell v. State Farm began reining in punitive state judgments following Gore, Miller, Gentry, Alfred, and Ingram had large punitive awards and indicate that the trend is reversing. Interestingly, Alfred and Ingram were tried, given very large awards, appealed, awards were reduced, and then settled privately prior to appeal to the U.S. Supreme Court. In conclusion, it is always advisable to file with the EEOC, even when not compelled to do so by state law. Cases indicating substantial reprehensibility or clear violation may provide greater awards in state courts. Some states have extensive discrimination protection, but state laws vary widely, and concerned parties should consult the National Conference of State Legislatures Employment Discrimination Guide, noted and works cited, to learn which states offer which protections to which categories. File quickly to avoid exceeding filing periods and suffering administrative closure. Companies will often wish to avoid negative publicity and may be willing to settle early in the process. Claimants with difficult cases should consider these offers seriously if they provide an equitable solution. This concludes my presentation. Thank you for your attention.